What happens if you bring a lawsuit and you exaggerate your injuries, make them worse than they really are? You want to know what happens? Come join me on this walk along the beach as I share with you exactly what happens. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You know what will happen? The defense will recognize that your injuries have been exaggerated. He will show and compare and contrast your true injuries with what you claim them to be. The defense will do everything possible to show that you, my friend, are a liar. They will do everything possible to show that your injuries really are not as extensive and as exaggerated as you claim them to be. And how will he do that? Let me share with you the different ways. There are many different ways to expose someone who is exaggerating. One of the key ways is to scour every single page of every single hospital record or medical record in your chart. Now, the idea is that at the time you are seeking treatment, you are going to be as truthful as possible with your treating doctors. Why? Because you want them to take care of you, you want them to do what's right, and you want them to know every single thing that's going on with you. The common thinking is, at the time that the injury has occurred and that you are receiving treatment to fix whatever problems you have, you are not exaggerating. And in all likelihood, you are not contemplating any lawsuit at that moment. So the idea is that you are being honest and truthful with your treating doctors. So now the defense, in preparation for your question and answer session, known as a deposition, will go through every single page of every single record that you have. And now, when they go ahead and question you in this pretrial process known as a question and answer session, lawyers call it an examination before trial. It's also called a deposition. And the answers that you give in response to questions posed to you by the defense attorney carries the same exact weight as if you are testifying at the time of trial, in front of a judge, in front of a jury. So now the answers that you give during the pretrial litigation process are extremely important. They are given under oath, and there's a court stenographer there to record all of the questions that you are asked and all of the answers that you give. The defense attorney is going to give you, the injured patient, the injured plaintiff, an opportunity to go ahead and explain in detail exactly what your problems are today. They are going to ask you what injuries or limitations you have now as a result of whatever was done. They are going to ask you what you can no longer do and what you do with difficulty. If you now go ahead and exaggerate all of the injuries that you are claiming, yet your medical records don't contain the information that you believe you really have, you, my friend, have a problem. Why? Because not only have you likely contradicted yourself, but the medical records, the doctors that you have gone to go ahead and treat your problems, don't contain any of the information you've now disclosed to the defense attorney. And because of that, you now have contradictions. Because of that, you now have credibility problems. And now you're going to have a significant problem when you go ahead and try this case in front of a jury to try and explain away how your injuries really are as bad as you claim them to be. If you are unable to do that, if you are unable to confirm the extent of your injuries with medical experts, with medical doctors who have been treating you, and now here you are claiming that you can't do the following things and do the following things with difficulty, yet none of that information appears in your treating doctor's records, you have a problem, and it will be a credibility problem. And once that occurs, you now have a bigger problem. If you create a credibility problem for yourself, that could literally destroy your entire case. These civil lawsuits are based upon credibility. It's all a matter of whether or not the jury believes what you are saying is true. Does the jury believe you? Does the jury believe the doctor who treated you? Does the jury believe the defense's medical experts? It's all a matter of credibility. And if you have done something to destroy your credibility, such as exaggerate your injuries or overstate the extent of your injuries and things that you can and cannot do, or go ahead and outright lie about something, and now the defense catches you in this lie, you have a significant problem. At the very end of your case, very end of your trial, the defense attorney is going to ask the judge to give the jury a legal instruction. And it's a very important one for you and what we're talking about right now. It has to do with credibility. And it basically says, okay, listen everybody, if you believe that this injured patient has testified falsely about one thing, it could be a tiny little thing, you, the jury, have the right to disregard part or all of this witness's testimony. They call that falsus in uno. That's a fancy Latin phrase that basically says, look, if you believe that this witness has lied about one thing, there's a good chance he's lied about other things, which means that your credibility is so crucial and critical to your success that if you do anything to destroy your credibility, no matter how little it is, guess what? You've now eroded the likelihood or the possibility that you will be successful in your particular case. So why do I share this quick information with you? I share it with you because most people don't recognize and don't understand the significance of what it means to go ahead and exaggerate part of their claim, to exaggerate injuries that they have that are not supported by the medical record, by their own treating doctor's records. In that instance, you're going to have a problem. You know, I recognize you're likely watching this because you want to see the beautiful scenery. No, I recognize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit and are thinking of doing so, but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.